this will be my video lecture for NSTP 2. No? So before I proceed with my lecture for today, I'd like you to have a copy of the Constitution with you so that each time that I discuss a particular section, you could easily follow through. Okay? So we begin with section 12. We were able to finish section 11 of Article 3 of the Bill of Rights last time. So we proceed with section 12.1. No? Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent. No? So this was your assignment that I gave last Saturday. You still remember the Miranda Doctrine. This is called the Miranda Doctrine, wherein if you are taken under investigation for a commission of an offense or a felony, then you have the right to remain silent. No? Meaning to say that during interrogation, if you are asked a certain question about what happened or what transpired in the commission of the crime, you may refuse to answer because of the so-called Miranda Doctrine. No? Meaning to say that you are at liberty. No? You have the opportunity not to say anything because that might incriminate you as an accused later on. Why do you have that right or opportunity? Because anything that you say during investigation or during interrogation may be used as evidence against you. So if you were taken under custodial investigation or interrogation, then better not to say anything, better to remain silent and not say anything about the commission of a crime. And also, it is your right, no, under this section, to have the assistance of counsel. No, counsel meaning a lawyer. Why is that? Because a lawyer is definitely knowledgeable about the technical rules of procedure in trials or in the litigation of cases. So we require that the accused should be given a lawyer, counsel. Now, and that is also stated in section 12.1, no, of the Bill of Rights. Why do you need, what if you cannot afford to have a counsel because it might be too expensive to be hiring or engaging the services of a lawyer? Then the court can designate one for you through the PAO. No, yung PAO, you know the PAO, the Public Attorney's Office. So they will be designating a lawyer, especially if you're a pauper litigant or you cannot afford to have counsel. Then they will just request the PAO, the Public Attorney's Office, which is under the Department of Justice, and designate a PAO lawyer. No? So in that case, you will still be represented by a lawyer. No? Okay, we proceed with number 2. Of course, here, it is very specific that if you are under investigation, no, they could not employ any torture, no, force, violence, threat, intimidation, or any other means by which your consent will be vitiated, no? Because if they do that, if they employ threat, intimidation, duress, no, you do not have free will at all. So if you do not have free will, that is taken under the spell of fear. No, you are fearful. That's why you gave those statements. So the law or the Constitution prohibits, no, the use of torture, of force, violence, threat, intimidation to any person which will be under investigation, because that will reshape, we call that reshape the consent or the free will of that person. No? Now, the problem is, under number 3, any confession or admission obtained, no, in violation of the section 12, or this is under violation under section 17 hereof, no? Under section 17 hereof, shall be inadmissible in evidence. Meaning to say that once you are already on trial for the commission of an offense, and then whatever testimony or statements you issued, which were taken under force, violence, intimidation, threat, etc., that will not be admissible as evidence. No, meaning to say, even if you maski inamin mo, no, even if you admitted the commission of that offense, but you admitted it because you were forced, no, there was employment of force, or there was employment of torture, or there was employment of violence by the police, then you could always invoke this particular provision, because the Constitution prohibits the use of force, threat, intimidation, violence, etc., etc. Okay. Number 4 of section 12 would say the law shall provide for penal and civil sanctions, no, in case there is a violation of this particular section. So the prominent feature of section 12 is what we call the Miranda doctrine, no, that the accused or the person under investigation has the right to remain silent. So he need not say anything about the commission of the crime, and that is his right as a citizen, no? And of course, why do you have that right to remain silent? Because that might incriminate you. It would be better that the issues or the facts shall be fleshed out in the proper forum. And the proper forum is, of course, the court, no? Okay. Section 13 would say all persons except those charged with offenses punishable by reclusion perpetua. Reclusion perpetua is life imprisonment. Yung reclusion perpetua na nandyan, no? So, it says that all persons except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall before conviction be bailable. No? So, you could see, even if a crime has been committed, basta hindi yung reclusion perpetual, yung punishment, yung life imprisonment, then that crime or that person can still be allowed to put on bail. Yung bail yung para to give you your temporary liberty. Kaya bailable offense, kung bailable offense yun, pwede pa siyang makalaya temporarily habang nililitis yung kaso niya. No? That is what's meant by section 13. Now, we proceed to section 14. 1. No person shall be held answerable or to answer for a criminal offense without due process of law. No? What does that mean? Well, of course, every accused, because we are talking about criminal cases or criminal offenses, every accused has the right to remain silent, no? Meaning to say that if you do not want to say anything about that crime, no, you can do that by virtue of the Miranda doctrine. Now, also, if you have been accused, no, you have been under investigation, you will have a day in court. And that day in court, the opportunity to be heard is what we call due process of law, which I discussed last time. No? There are two aspects of due process. By way of review, I will repeat. The first aspect is what we call the substantive aspect. Substantive due process of law. We're talking about due process of law. Due process of law. And there are two aspects of due process of law. The first one is what we call the substantive aspect. Substantive aspect. The second one is what we call the procedural aspect. No? We've taken this up before. And these two requirements, the two aspects, have to be complied with. No? So, substantive meaning we're talking about the basis, no? Legal basis. No? There is a particular provision in the law that says this is prohibited, etc., etc., and you were able to violate that. No, that is substantive aspect. No, meaning there is what we call the legal basis. Procedural, of course, I told you you will be given a day in court. Procedural meaning there should be proper hearing or proper trial to litigate your case. No, that is due process of law. Okay, so we proceed with section 14, number 2. In all criminal prosecutions, the accused shall be presumed innocent. Well, this is also a very basic and very important doctrine, no? In criminal cases. Maski alam mong ginawa mo na for a certain crime, even if you think or you know very well that you have already committed that offense or that crime, you still have the right to say that you are still innocent. No, you are presumed innocent unless proven otherwise. Okay? So if I will explain, if this is the accused yung tingin natin is siyang gumawa ng crime. If you are the accused, still you have the right, you are presumed to be innocent. No? Innocent ka pa rin sa paningin ng batas. And this one, to prove this, of course, there will be a trial. No? Or the trial that we call, no? Criminal trial. It is presumed that you are innocent even if you know that you have already committed that crime or that offense. You are still presumed to be innocent, meaning innocent ka pa rin before the eyes of the law. And how do they prove that you are not innocent for the commission of the crime? Not innocent will be through the proper trial, no? Presentation of evidence, testimonies, statements, etc. That is how to disprove that you are not innocent. Okay? So we proceed with section 15, talks about the privilege of the writ of habeas corpus. Writ of habeas corpus would mean produce the body. No? Produce the body. Meaning to say that produce the body, the privilege of writ of habeas corpus shall not be suspended at all. No? So, at any time, you could always ask for a writ of habeas corpus. So, halimbawa, nawala yung accused, no? At large, no? Then you apply for a writ of habeas corpus. Well, that should not be suspended at all, according to section 15. Shall not be suspended except in cases of invasion or rebellion. So, the writ of habeas corpus can never be suspended except in those cases, rebellion or invasion. Okay, we proceed with section 16. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. No, very clear. In all judicial, quasi-judicial, and administrative bodies, you are entitled to a just and speedy trial of your cases. Hindi dapat pinapatagal, no, yung pag-litigate. Because if you do that, a very long litigation or a very long trial is already considered as justice denied. I think I have to stop from here. Then we will proceed from section 17 to 22 next time. I will just be writing down your assignment through our group chat. Okay? Good afternoon. Good morning, everyone.